So speaking from public policy point of view, when we speak of Justice Puttaswamy judgment, in August 2017, it was a 9-judge bench of the Supreme Court, and Justice K.S. Puttaswamy, who was a retired judge, versus Union of India. In this judgment, it unanimously held that Indians have a constitutionally protected fundamental right to privacy that is an intrinsic part of life and liberty under Article 21. As we know, all rights emerge from natural right, and it held that privacy is a natural right, which is inherited by all natural persons, and that the right may be restricted only by state action that passes each of the 3 tests. Now, there were 3 tests which was given. Number 1 was that such state action must have a legislative mandate. Number 2, it was that it must be pursuing a legitimate state purpose. And number 3, it said that it must be proportionate. Such state action, both in its nature and extent, must be proportionate to its justification. And it should be necessary in a democratic society, and the action need not be least intrusive of the available alternatives to accomplish the ends. So privacy judgment was considered as a guiding tool, and we still consider it as a guiding tool because as a landmark judgment, it did not just fundamentally change the way in which the government viewed its citizens, be it their privacy or both in practice and prescription, but also it requires government and even private bodies to undertake structural reforms and bring transparency and openness in the process of commissioning and executing its surveillance, be it with regards to projects, schemes, build a mechanism of judicial oversight over surveillance requests. It demands from the authorities to demonstrate great care and sensitivity in dealing with personal information of its citizens. It also requires a legislative, transformative, right-oriented data protection law, which just came, on August 11, which will hold all powerful entities that deal with citizens' personal data accountable, which will also include the state. Now, what steps have been taken with this regard to strengthen privacy regime? As we know, data protection bill was introduced in 2018 as per the recommendation of B.N. Sri Krishna committee report, and the same was taken as a law and brought into a law on August 11, 2023. That report of B.N. Sri Krishna committee had a wide range of recommendations to strengthen privacy law in India. Its proposal included restriction on processing and collection of data. It said data protection authority has to be created, which will have the right to be forgotten. So if a data has been collected, it will also be removed. There will be a right to forgotten. There will be no digital footprint unless until a person consents about it. There will be data localization, say data is originated in India, it will go by the sovereign rule of being locally stored. Then explicit consent requirement for sensitive personal data. Information Technology Act of 2000, which is the IT Act, also provides for safeguard against such breach in relation to data from computer systems. It contains provisions to prevent the unauthorized use of computers, computer systems, and data stored therein. Then, what happens when we speak of K.S. Puttaswamy, or we also speak that there has been little change in terms of narrative that local people, as citizens that we have in our head, we are still very careless when we are giving out the data. We are not as particular as, other countries with other developed countries, I would say, who practice these, these regular, systematic way of data assimilation. Now, there may be various aspects with regards to national security versus privacy, which comes into light. I would also say that Ministry of Home Affairs in December 2018 authorized 10 central agencies to intercept, monitor, and decrypt any information which generated, transmitted, received, or stored in any computer in the country. So even before the law came into pictures, there were safeguards which were being taken, into action at the government level, because it is an important aspect. In July, again, the same year, 2018, it also became to be known that Ministry of Information Broadcasting had floated a tender for social media monitoring hub. So now that the law comes for us as citizenry, but with regards to institutions, there were safeguards which were made. And this was only because of the N. Sri Krishna Committee report and case Puttaswamy judgment. So yes.